Ready, start. However, this fact is sought to be distinguished by the respondents on the ground that it was an appointment in an autonomous body and therefore it will not amount to any regular recruitment as understood under the observation rules. Full stop. We are unable to accept this stand in the counter affidavit in as much as the very letter of appointment of Shiv Prakash Sharma itself refers to Senani Kalyan Parishad to be governed by the government order dated 23 December 2001 and observation has been acknowledged an account of Shiv Prakash Sharma being a retention employee. Full stop. Thus, there is no doubt that the observation of Shiv Prakash Sharma was clearly on account of his retrenchment after he had withdrawn his writ petition. Full stop. So far as the status of the Senani Kalyan Parishad is concerned, a reference to the office memorandum dated 12th February 2009 issued by the government of Uttar Pradesh would clarify the position. Full stop. In clause 4 of the said memorandum, it has been categorically stated that the Senani Kalyan Parishad shall be a government institution. Full stop. In our considered opinion, the said organization, therefore being a government institution as described in the office memorandum, itself negates the arguments advanced on behalf of the respondent that it was governed as a separate entity, an autonomous body and not a government department. Full stop. The observation of Shiv Prakash Sharma was in a government institution. As such, no distinction can be drawn on that count insofar as the case of the applicant on priority for the observation is concerned. Full stop. Para. Coming to the question of applicability of the 2003 recession rules, suffice it to mention that the issue of observation had already been raised immediately upon the corporation being wound up in the year 1999. Full stop. Thus, the status of re-examination was already being faced by the applicant and they had already raised their claims much prior to the enforcement of the recession rules, 2003. Full stop. The said fact is also fortified by the fact that the interim order was issued on 25th May 2000 directing the state government to consider the same. Full stop. Consequently, the entire exercise has already commenced and the state government having failed to take a decision, the rights of the applicant had already characterized the adjudication whereof has now been made under the impugnment judgment. Full stop. In such a situations, the conclusion drawn by the learned single judge that since the employee have been recruitment after the recession rules 2003 now where affect the rights of the applicant, whereas in fact the applicant were already facing the reenactment and they were entitled for consideration of their rights accrued earlier as already pointed out in the judgment of Vinod Kumar Kushwaha and other judgment in the connected writ petition. Full stop. Learned Standing Counsel for the state also informed the court that the aforesaid status of the reenactment and its effect has been discussed in a later decision of this court of a division bench after the considering the impact of the earlier judgment in this regard and in this view of the matter also the appellant would not be entitled to such any benefits. Full stop.